Good afternoon, everybody. Thank you so much for joining us. My name is Giselle Perez Astwood. I'm the symposium editor for the Rutgers University Law Review. Again, thank you for joining us. We're going to start the discussion very, very shortly, but before we begin, I wanted to take a moment just to thank some of the people who made the symposium possible. First, the Rutgers Center on Criminal Justice, Youth Rights, and Race, led by Professor Laura Cohen. She has been a guiding light to all of us. The symposium team, Madeline Gale, Jennifer Monhay, Mary Claire Patterson, and our symposium committee made up of Leah Dice, Gifty Minnow, Holly Maynard, Michael Lynch, Matthew Grillo, all wonderful members of the Rutgers University Law Review. I'll talk to you a little bit about why we decided to do this program. The pandemic has been difficult on all of us, but it's been even more difficult after witnessing via video footage the grotesque murders of George Floyd, Ahmaud Arbery, Breonna Taylor, so many injustices that have happened recently in the nation. And unfortunately, these are not new injustices to our country, but fortunately, they've allowed for very productive discussions, and we wanted to also participate in these discussions and look at things from the angle that maybe most discussions haven't been taken. Most discussions have been taking the policing angle, but we know that prosecutors also have the capability to be agents of change, so that we're hoping that this symposium can also help us enter the discussion and build an anti-racist prosecutorial system. I will be handing the program over to Dean Lopez to give a couple of other remarks. So Dean Lopez, whenever you're ready.
Thank you all. Thank you very much, Giselle. And thank you, all of you out there. I see that we have approximately 140 participants, many of whom are working within the criminal justice system, many are students. So thank you all for joining us in the latest of a series of discussions on prosecutors' power and racial justice, building an anti-racist prosecutorial system. I'm really proud of the work that the Rutgers University Law Review and the Rutgers Center on Criminal Justice, Youth Rights, and Race have done in this series. It really is bringing national attention to the work Rutgers is doing to shed the spotlight on a broken system, a system of a criminal justice system that's marked by really gross disparities, racial disparities, and really a lot of inconsistency and incoherency. And so this series has explored these issues for many today we have a panel to be moderated by my predecessor. I'm very jealous. My predecessor, Dean Ronald Chen, who now gets to do all the fun stuff. I look forward to this outstanding panel. I'm having an instability problem today, both with my connection and otherwise. So I'm going to pass it over to Dean Chen before I get bumped off again. But thank you all, to all you panelists, for joining us today. Thank you, everyone, and I really look forward to a very robust and enlightening discussion today.
Oh, thank you so much, Dean Lopez. As you said, I'm Ron Chen. I now am happily a full-time faculty member at the law school. I'm also the faculty advisor for the Rutgers Law Review, a co-advisor here resident in Newark. And I also would like to express my great pride and appreciation for the Law Review under my colleague and friends, Professor Laura Cohen's guidance to putting this program together. It is, in reading the précis that our very distinguished speakers have prepared, I think this will be an exceptional program. I will not prolong these proceedings too much with either any remarks of my own or extended biographies of our speakers, frankly, for fear of inadvertently doing any of them an injustice because of their varied and distinct backgrounds. Their bios are available in the symposium program. Just a matter of housekeeping. For those of you who wish to get CLE credit for this program, CLE credit is available for New York, New Jersey, and Pennsylvania. Information on that will be in the chat room. There will apparently be 2 secret code words. Probably those of you who watch these things know what I'm talking about, which I will, and for any of you who are in by just dialing in by phone, I will recite them. So that will be available. These will also, I note, this will count also as a diversity CLE, which, as in New York last year and New Jersey starting this cycle has required as well. So that would be very welcome as well. So with that, I'll just briefly introduce our speakers, and then we'll go right to the program, which will be each of our 4 speakers will speak for about approximately 20 minutes on the topic they've chosen to present, many of which will be reprinted in more formal format in the Rutgers Law Review. And then after that, the last, that should take us to about 5:30. And the last half an hour, we will make available for a Q&A from attendees. If you wish to ask a question, you should see the Q&A box at the bottom of your screen. Try to use the Q&A box, although if I see it come in the chat, I will try to take note of it as well. So I just want to then briefly remind you of our luck in the speakers we were able to get for to participate in this year's program. In no particular order, Professor Fareed Hayat, who's a professor at CUNY Law School, just across the river, our metropolitan area neighbor. Prior to CUNY, Professor Hayat was the co-director of the Criminal Justice Clinic at Howard University Law School. Professor Kristen Henning is the Bloom Professor of Law and Director of the Juvenile Justice Clinic at Georgetown Law School. And as we were coming, he is a survivor of the Office of Associate Dean, a situation that I can share from personal experience. Professor Irene Joe is a professor at UC Davis, a law school where she teaches criminal law, criminal procedure, and professional responsibility, which will be relevant, I think, in her remarks. And Mr. Adewale Oduye, formerly a prosecutor with the Los Angeles District Attorney's Office, the largest county prosecutorial agency in the nation, who will, of course, speak from his experience as a former prosecutor. So with that, I think there's no reason to delay any further. So let me first call upon Professor Irene Joe to give us her introductory remarks.
Thank you so much. I'll go ahead and start sharing my PowerPoint. It's a brief one. We'll see how this all goes. Let's see. Everybody see that okay? All right. So thank you all so much for being here today, and thank you to the Rutgers University Law Review for developing and holding this really important symposium on anti-racist prosecution. Over the last few years, mass incarceration and the solutions to the problems of mass incarceration and racial bias in the criminal process have become the hot topic, right, or buzz topic in criminal justice circles. Mass incarceration or mass imprisonment, the prison boom, the carceral state, they all refer to this current American experience of comparatively and historically high rates of imprisonment and the concentration of imprisonment among young people of color who live in disadvantaged communities. I mean, we have images like these where inmates are basically stacked upon each other in criminal facility after criminal facility, making it clear to the vast majority of people that something needs to change. And it's whether they have that feeling, whether or not they are concerned about the racism that historically and currently plays a part in the criminal process, or the human capital and life experience and what it means to be incarcerated at various points in your life or for your entire life, or they might just be concerned about it because of the cost of managing and providing basic standards of decent care for those who are incarcerated. So you have progressives and conservatives alike agreeing that we should not have a system like this. We've got defense attorneys, legislators, and some prosecutors trying to figure out what they can do to reduce the costs of a system that has proven burdensome to so many communities along racial dimensions. And the general public seems to think all of this attention is warranted. But despite all of this attention, and at least an outward dedication to improving the criminal justice system by pursuing anti-racist policies and procedures, we haven't, by my mind at least, seen as much change as we would expect with all of this noise out there. Defense attorneys, legislators, and even some prosecutors still think, we have an unacceptable system and the public agrees with them. But I think the reason we haven't seen as much change as you would expect with all of this attention is because we've identified a problem, but are pushing forward the same conventional solutions that have already proven inadequate or politically impractical. The first is decriminalization, right, or legalization of certain behaviors that were once classified as criminal. The theory goes that we've just criminalized far too many things, whether it be drugs or other petty offenses like theft of a small amount. And so we could pursue this legalization of decriminalization path to remove those from the criminal arena or shift them in some way. There can be civil sanctions for it, or just no sanctions at all in the case of a certain type of use or involvement of marijuana, for example, or just a reduction in the type of punishment and collateral consequences one could face for a criminal charge in those areas. The second solution that has proven inadequate is finding money in already stretched state budgets to increase funding for public defenders, right? I'm certainly one of those people that has advocated for that, both in my practice as a public defender in the past, and then also in my legal scholarship. Basically, instead of spending so much money on prisons and policing, we could invest the money in those public defenders who represent defendants and allow them to do what we call holistic representation. These ideas are all part of a broader solution, but they have just proven insufficient, right? We've got states that have pursued the decriminalization or legalization path that are still struggling with overloading the criminal system. And state budgets are stretched, right? If we've already got people incarcerated, where are we going to be able to pull money out of these prisons without, sort of foregoing or abandoning our standards of human decency? So my goal with my current research has been to advance a new solution for this problem that's both novel and achievable. It's novel because it focuses on the prosecutor's charging decisions in the aggregate as a whole and not on an individual level. That's something that has received relatively little attention in the debates about criminal justice reform. And it's achievable because it uses tools that are already a central part of our legal system, our process, the model rules of professional conduct. One of my papers, Regulating Mass Prosecution, which I'll speak about for this talk, seeks to address the problems of mass incarceration and racially biased criminal process outcomes by articulating a new theory of prosecutorial discretion that more aptly recognizes the role that prosecutors play in excessive public defender caseloads, right? These caseloads that contribute heavily to mass incarceration and the disproportionate criminalization of Black and Brown people. My plan for this talk is to spend a few minutes giving you an overview of my scholarly approach to the subject area, then a few more describing the implications of some of my projects before diving deeper into the specific rules that I think should inform our approach to modern criminal justice administration, because they would more adequately address some of these problems that we've identified. I use these model rules of professional conduct as my primary lens for considering prosecutorial obligations when it comes to public defender caseloads. These are the rules that guide the legal profession, and each state has adopted some form of them. And it's these rules that I'm using to present a new approach to criminal justice reform. They are based on this idea of a lawyer, as you can see from this quote, who's an expert engaged in public service for the public good. And that's captured on this broad level. I'm relying on this rule 8.4 of the model rules. That's this rule on attorney misconduct. And the basic premise of that rule is that one lawyer shouldn't engage in behavior that would lead another lawyer to violate professional and ethical rules. So on a more particularized level, I'm also considering how prosecutorial charging decisions implicate a defense attorney's ability to comply with the professional duties they are called to provide in representing defendants, those of loyalty, competence, and the overall duty of maintaining the integrity of the legal system. I write and research primarily at the intersection of criminal procedure and professional responsibility, and I've been particularly concerned with the public defender caseload crisis in this sort of early stages of my academic career. I'm not sure a description of that crisis is completely necessary in this setting, since most of you attending are probably sort of aware of it. But just to give you a short sort of caption of it, public defenders have been battling with and seeking solutions to the problem of having too many clients and not enough resources pretty much since the days after the Gideon versus Wainwright decision came down affirming the right to state-funded counsel. So we can all recognize that clients for the public defender, of course, are individuals charged with misdemeanors and or felonies who cannot afford to hire their own attorney and are thus deemed indigent. But it's probably worthwhile for me to explain what I mean by them being overloaded or having limited or insufficient resources. The resources that are so limited in the public defender representation context are time, the lawyers themselves, experienced lawyers as a particular type of resource. That was a subject of an earlier project I wrote for the UCLA Law Review. It could be investigators, administrative staff, funds for expert witnesses, and even things that we would consider basic, like office space, computers, filing folders to organize client materials, and staplers. Yes, I can say from experience that filing folders were in short supply during my time as a public defender in New Orleans. And some of my old colleagues actually have a really now somewhat funny email I sent office-wide admonishing whoever had stolen or borrowed without returning, as they called it, the stapler I had to purchase with my own funds. So there's this large gap between available resources for defense representation and what defendants should get, and in some contexts are constitutionally entitled to receive. But that gap has been discussed in the legal literature, and there just hasn't been enough purchase of it to my mind. I mean, in 1973, there were these the National Advisory Commission on Criminal Justice Standards and Goals actually issued guidelines for public defenders that are routinely surpassed. And these guidelines say that they are supposed to handle no more than 150 felonies for an entire year, or 400 misdemeanors for the entire year. But we all are familiar with stories of public defender after public defender, office after office that is forced to deal with much, much more than that. I mean, this was the sort of thing I dealt with as a public defender in New Orleans, right? As a line defender there, I was juggling hundreds of cases at a time. So the average over the year was much more than that. And as a training director for the state of Louisiana, I worked with people who had caseloads of around 500 at a time. So every week there's another news story about public defender offices that are completely failing or finding it so incredibly difficult to meet the basic guidelines of providing effective assistance of counsel. But there's still little in the way of change and reform. So in my research, I look at it through a different lens. I don't spend too much time focusing on the constitutional implications of the public defender caseload crisis. And instead, I look at what the ethical and professional rules say about the other system actors and what they should be doing to make sure that the public defender is able to provide the effective assistance of counsel, right? So we can understand that a case only gets to the public defender once the prosecutor has instituted charges against the defendant. That's a gross oversimplification of things. So anybody who has not taken criminal procedure yet will provide more context for you in that class. But for our purposes, sort of understanding it, the prosecutor decides the case should go forward, they file the charges, or the grand jury puts forth a true bill, and then the case goes forward. And so within that framework, we understand and recognize that probable cause is this ordinary formal mechanism that prosecutors use to make their charging decisions about which cases are going to go forward. And probable cause requires the prosecutor to have an objective belief that the defendant has committed a crime. So we have that formal standard, But by my mind, there are all these other informal standards that prosecutors can use to decide which of the many cases that might be falling on their desk they should actually use the criminal process for. I'm working through an exhaustive list of those informal considerations, because they could include things like, of course, the harm that might be caused to any victims, maybe a defendant's prior record, things like that. And also maybe the personal goals of the prosecutor, what they need to do or they feel they need to do to keep their job or to pursue higher office, right? And my central thesis for this project is that because of ethical and professional guidelines and the model rules that guide attorney practice, prosecutors should also consider the impact on the public defender's own ability to comply with ethical rules when they are making their charging decisions, right? We have this fundamental notion, as I mentioned, that one lawyer can't engage in behavior that would make another lawyer violate ethical rules. And my thought is that when prosecutors bring so many cases that a public defender is overwhelmed, they are doing just that, right? And in fact, they're not just putting public defenders in a position where they're more likely to violate ethical rules, but the prosecutors themselves are jeopardizing their own adherence to many of the same rules, right? So in my research, after detailing the formal and informal considerations that are available for the charging decisions, I turn to the individual rules and I ask whether or not prosecutors should be reconsidering things given the implications on those. The first one is the duty of loyalty, right? That's been written about a bunch in terms of the inherent conflicts that arise when a public defender has too many cases. They have to pick and choose which of the clients they're going to dedicate what we might consider quality, significant attention and time to. Another rule that I look at is the duty of competence, right? And I actually detail it as both a problem for the prosecutor and the public defender. For the public defender, that duty of competence concern is kind of obvious, right? If you're just dealing with so many cases at the same time, if you have a caseload of 500, you're not going to be able to spend as much time and dedicate as much of your knowledge and skills to each individual client. For the prosecutor, it's a similar story implicating a different client, which was another sort of research track I pursued, which was sort of thinking through who could we define as the prosecutor's client in a case, right? If we wanted to sort of imagine it as that, would it be the law as this sort of like theoretical entity? Or would it be the community the prosecutor serves? And if so, they have to think about what their representation or what their charging decisions, the effect those charging decisions have on the community they're looking out for and they're seeking to represent to some degree, right? And that also really plays a part when we think about the consequences, the outside effects, the secondary effects of prosecution on family structures and different sort of community environments, right? So those are also potential things that the prosecutor should think about. And then third, of course, is this notion of the maintaining the integrity of the legal system. Here is where the lawyers, prosecutors are required to do something more to make sure the system is one deserving of respect and operates with integrity. This next slide, I think, really emphasizes the impact charging decisions have had on the integrity of the legal profession, right? This is a prop that actually sits in my office in Davis, right? There was a real life comic book here, right? Here's a picture of one of the covers that existed in the mid 1950s, a comic book that actually extolled the virtues of the public defender. It was a superhero type comic book that involved a public defender representing those who had been falsely accused and fighting hard for clients, finding clues, right? We've got the vanished clue here that were otherwise hard to find and presenting them effectively before decision maker. It's fascinating to see this because it suggests there was a time, interestingly, before the Gideon decision in 1963, when there was this vision of the public defender as a Clark Kent or Batman type superhero. And that sentiment can be really hard to find in modern jurisdictions where the PD is overwhelmed. Many of us may recognize that public defenders are extraordinary attorneys who are making sacrifices and doing the best they can. But we also see that there's only so much you can do when you're overwhelmed and you're trying to fight a battle with limited resources. I see that I'm almost out of time. I'm really looking forward to talking about these ideas a little bit more in the question and answer. And thank you so much for listening to my comments, and I'll turn it over to them.
Dean Chen, you're on mute.
Sorry, even after a year of Zoom, we sometimes forget. Thank you so much, Professor Joe. And next, we'd like to hear from Professor Hayat.
Greetings, everyone. I'm very happy to be here as well. And I'm here to talk about something that many of us don't have on our radar, and that's the prosecution of so-called and actual gang members. And what can prosecutors do to be progressive or ethical and create an anti-racist prosecutorial system? Well, the first question I ask you is, what's the difference between progressive and ethical? Because progressive seems to suggest that a person will advocate for implementing social reform and new ideas, while ethical is really about following the rules. As Professor Joe talked about, we have rules of professional responsibility, we have constitutional rules, we have procedural rules that suggest that can we follow those? So as it relates to creating an anti-racist or an ethical space for prosecutors to exist in prosecuting gang members, can we at least ask you to follow the rules? Now, me personally, I believe that gang prosecution should be abolished, that gang prosecutions are a badge of slavery and that they were designed to largely punish and prosecute Black and brown people, and that's in fact who they do prosecute. But for those of us who believe that there is a space where those people are considered gang members should be prosecuted, my request is to do it ethically. So the question becomes, can you be an ethical prosecutor? I ask my students this question all the time. Well, could you have been an ethical slave catcher? And the question is, if a prosecutor's job is to enforce laws and to prosecute, to lock you up in a system that is fundamentally unjust and is racist and is an offshoot of slavery, can we be ethical in executing that system? Well, I think we all would agree that we could not be an ethical slave catcher, that to put one back in slavery, there's nothing ethical about it. But the question becomes, as it relates to prosecution, can you do some good? Is there a way that, yes, we can acknowledge that the system is flawed, that is based in slavery, but we'll do some good? Imagine a slave catcher that does not rape and maim those who he captures, but simply bring you back to enslave you. Now, you're not going to upend the system, but you absolutely can do some good for those individuals that you don't rape and maim. And that leads me to my discussion of someone who has gotten the title of ethical prosecutor largely because of the good work. Oh, I think my mouse has died on me in the middle of my presentation, so I'm not too sure if I'll be able to get to my next slide. So I'm going to have to wing it, which is okay with me. I'll talk to you.
Try your space bar.
Oh, it's not working at all.
I'm sorry.
But nonetheless, no worry, I don't need the PowerPoint. So I wanted to talk about George Gascon. And George Gascon is the newly elected prosecutor in Los Angeles County. And George Gascon ran on a platform of not bringing death penalty cases, on not prosecuting and bringing gang enhancements, as not charging juveniles as adults, and limiting drug prosecutions under these ethical or anti-racist approaches. And what has happened with George Gascon is that lying prosecutors have revolted. They have literally sued him in courts to say, you don't have that discretion to decide what not to bring. That ethical approach that George Gascon has demonstrated is what I think I'm asking for prosecutors across the nation to do, to acknowledge that there are fundamental problems with our system and exercise their discretion in saying, we will no longer bring these kind of cases. And if we do, we will abide by constitutional limitations, we will abide by rules of evidence, and we will give a defendant a fundamentally fair shot. Gang statutes. Well, gang statutes should be abolished completely. They are badges of slavery and they further white supremacy, and they are almost exclusively used against Black and brown people. There's a real human cost of gang statutes. Across the nation, over 90% of the people added to gang databases are Black and Latino, even though estimates from police officers show that 25% of gang members are white. Across the nation, there has never been a prosecution of a white nationalist gang under a gang statute. Now, white prison gangs have been prosecuted, but no white gangs have been prosecuted under gang statutes, and that's from my research. In Mississippi, 100% of the people arrested under state gang statute laws between 2010 and 2017 were Black, despite Mississippi's own Association of Gang Investigators saying that 53% of verified gang members in Mississippi are white. This means that the protections afforded by the United States Constitution made applicable to Black people by the 14th Amendment are routinely denied to Black people by simply labeling them as gang members. It also means that Black people are receiving longer sentences than our white counterparts for the same crimes. Gang statutes by design enable this. They, on paper, and they're racially neutral on paper. There's no gang statute that says we're only going to prosecute this group of people. They're racially neutral. So they say we're going to prohibit a person from participating in a gang or conspiring to further a gang. In 28 states, you have to commit one predicate act, meaning one crime on behalf of the gang. And then not only will you be liable for that crime that you've committed, but you'll be liable for that crime in furtherance of the gang. And gang statutes, by design, permit you to be punished for both. Simple example, you sell crack cocaine. You face 20 years in the state of Maryland for selling crack cocaine. You will face an additional 15 years in the state of Maryland for selling crack cocaine on behalf of the gang. So you face 35 years that you can receive consecutively for that one simple act. So these complex criminal statutes, and that's what a gang statute is, threaten defendants by really putting this huge bargaining position in the hands of prosecutors by simply saying, I'm going to charge you as a gang member. Evidence that is otherwise inadmissible becomes relevant because prosecutors have to not only prove that the gang exists, but multiple members exist, 3 to 5, depending on what state you're in. They are able to bring in evidence about the actions of 3 to 5 other people that may be completely unrelated to that drug transaction that has occurred in order to prove the gang statute that says, not only did you sell the drugs, but you sold them on behalf of a gang, and these gang members commit all these other crimes. So substantively, now your jury is exposed to evidence that in a normal criminal trial, they would not be able to hear about. In addition, another major problem with gang statutes and why I'm asking ethical prosecutors to not use gang statutes is the use of gang experts, which are police officers essentially who get to testify not only to what they think your colors may mean or what your tattoos may mean, but who are able to offer to the jury what you think in your mind. What is your psychology? Why you do what you do? And the problem with this, of course, is that these experts who are not psychologists, who are not sociologists, who don't have valid and reliable means of making these determinations, are able to answer the ultimate question, meaning, did you commit this crime? And more importantly, did you commit it on behalf of the gang? And my final critique of gang statutes and why we ask ethical prosecutors to not bring it is because of violations of double jeopardy. And they're classic double jeopardy violations, but here we're going to focus on what are called collateral double jeopardy violations and the collateral estoppel doctrine that I'll talk about a little bit. So what can ethical prosecutors do? Not bring gang charges at all. Prosecute people for their substantive charge. And if you have the evidence of it, get your conviction. But if you insist on bringing them, again, bifurcate the substantive crime from the gang charge. And I'll explain what I mean by bifurcate. Do not use expert testimony to go to the psychology and the sociological effects of what gang members do. And finally, avoid double jeopardy violations and abide by the Fifth Amendment double jeopardy clause. So my suggestion, number one, ethical prosecutors should consent to bifurcation of substantive gang charges. I'll give you an example. A client is accused of a murder in 2007, and the state prosecutor at the time decides not to bring the charge because of insufficient evidence. That state prosecutor writes the lead detective and say, don't bring the charge, we don't have enough evidence. The gang statute is passed. Several years later, the new prosecutor, who now has this new law to bring this charge, brings that murder as a predicate act of the gang statute. And on the witness stand, the same detective admits there's been no new evidence that's been discovered in this 5-year period from the no evidence to bring the charge to now the charge being brought under the gang statute. In that trial, the defendant is in fact found guilty of the murder and the murder in furtherance of the gang. But the funny thing is, or the clear example of how the negative impact of gang evidence is, that defendant was found not guilty of a handgun and a crime of violence, the gun that was used to kill the victim, but found guilty of the murder. And upon asking jurors, how did you come to such a conclusion? A juror articulated, because we know they commit murders even if he didn't do that one. And this concept that a juror can take evidence of the gang and use it to rationalize a conviction for a murder is fundamentally unfair and violation of due process. Well, what is the answer? It's bifurcation. And bifurcation is a doctrine that really comes out of the case of Monell, which applies the standard that we're going to separate evidence that's unduly prejudicial, that will impact a juror's ability to make an unbiased decision and allow you to deal with that later. Specifically, it was the case of the city of Los Angeles versus Heller, where the Supreme Court stated that excessive force claims, so when we're suing police for committing excessive force, and you're suing the police department for creating a culture of excessive force, the court said that a plaintiff must show the unconstitutional force first. And only after a finding of that violation does the customs or policies that caused it are admissible. And the court essentially says that if there is no violation of your constitutional rights, then we should not hear about the customs and policies of the police department that caused it. Outright saying we're going to separate and allow officers to have a fair trial to determine if they violated your constitutional rights. Because one of the cases was there were training of dogs to bite people with dark skin. And all of the dogs were being trained to bite people with dark skin. And that evidence of a juror hears that every dog in the police department is trained to bite dark skin, you're going to assume that when my client was bit, it was because he had dark skin. The court said, no, you have to show that that particular biting was a constitutional violation before you get to talk about all of the overwhelming proof that all dogs are trained that way. That's bifurcation. And that's what we're asking ethical prosecutors to do in gang cases, to simply prove the substantive charge first and not use the other evidence to prove the substantive charge. And that will give us the opportunity to simply have a presumption of innocence and a requirement of proof beyond a reasonable doubt of a substantive charge. I'll move to the next question of what can ethical prosecutors do? Well, they cannot use expert testimony by gang officers. The example would be, gang officers say most of them across the nation have about 10 categories of how they identify a gang member. And these categories can be self-admission, it can be tattoos, it can be a number of things. In one particular case, a gang officer says that if you associate with other gang members, that would qualify as one of the factors to label you a gang member. Another one is if you use the gang symbol, that will qualify you as a gang member. So that officer was asked on a witness stand, so you said if a person associates their gang member, yes, and if they use the symbol, yes. And this here is the gang symbol, correct? Yes. So the question was, well, isn't that the peace symbol as well? Yes. So these qualifications of what will qualify one as a gang member are fungible, are not reliable. And there's been a recent indictment in Los Angeles County where at least 3 officers were indicted for alleging that individuals self-identified as gang members, even though body camera evidence of interviewing those individuals show that they say, no, I'm not a gang member. So this concept that now a gang expert can come into court and say, yes, they are a gang member and they did it on behalf of the gang member, as opposed to, yes, I've collected particular evidence of a crime and this is that evidence. And this isn't just like a couple bad prosecutors doing this. It's first by design by the statute because they require gang experts to come give this evidence. And then you have prosecutors literally going across the country, training other prosecutors to do this, to bring a gang charge. Alan Jackson, a former prosecutor, in his article, Prosecuting Gang Cases, What Local Prosecutors Need to Know, wrote, the easiest way to get gang evidence admitted in trial is by filing a substantive gang crime or an enhancement allegation. Once that charge or enhancement is filed, everything that the gang expert says becomes relevant to the charge, to the gang charge. So essentially, charge gang. An example being 4 individuals, youngsters, teenagers, friends, and cousins run into a swap meet store and snatch some t-shirts and run out. And not only are they charged with robbery, where maybe they should have only been charged with theft, but in addition, they're charged with stealing the t-shirts on behalf of the gang or in furtherance of the gang. So not only will they face the theft charge and the robbery charge, but now you get to talk about all the evidence from the gang crimes happening in the city and in that neighborhood to prove that they stole t-shirts. And this is this abuse on the carceral state of prosecutors of like expanding the carceral state with these kind of charges. The final thing I would like to talk about as it relates to a prosecutor exercising discretion and being ethical or being anti-racist is not bringing the double jeopardy violations. The example being, I gave the example, the individual is charged with distribution of cocaine. But imagine in this instance, the individual was found not guilty of dealing cocaine on that day. Not guilty, jury of 12 people. He walks out. 2 years later, he's charged with that same incident of dealing cocaine on behalf of the gang. Now, the statutes allows prosecutors to charge previously adjudicated conduct. And not just conduct that you were found guilty of, but conduct that you were found not guilty of in furtherance of the gang. So in this particular instance, that individual was found not guilty of cocaine on that day, but found guilty of dealing cocaine on that day 3 years later under the gang statute in furtherance of the gang. And the statute allows that. So this clear violation under Ash v. Swinson, which says that if a question of fact has been decided by a jury, that question cannot be relitigated. Ash was a case in which an individual ran into a poker game and robbed 6 people. And the jury tried him for robbing one of those 6 people. And the jury found him not guilty. And then Ash was charged with robbing the second person and found guilty. And the United States Supreme Court said, well, if Ash didn't rob the first one, it's not possible that Ash robbed the second, fourth, fifth, and sixth. So collateral estoppel says, no, we've made that decision. I'm not going to permit you to charge that person again. Well, gang statutes not only permit it, but require it. They're designed to have it, and they only require you to do one thing in furtherance of the gang in order to allow all this other evidence in. So finally, my conclusion, ethical prosecutors should uphold the Constitution. Ethical prosecutors should reject gang prosecutions entirely. They are badges of slavery born of racialized myths about violence and function of practice to overpunish Black and brown men. And ethical prosecutors should continue, who do continue to bring these charges, bifurcate them. Don't use these gang experts to testify to sociology and psychology, and refrain from using previously adjudicated conduct. Thank you.
Thank you so much, Professor Hyatt. Perhaps you could take your screen down.
I'm trying to. That's my issue.
Whoever's the major organizer, do you have control of the screen? Can you? Great, thanks.
Thank you. Appreciate it.
Yeah. Let me ask now. The first CLE code, the first two of the two CLE codes, has now been posted, and the code is youth. The word youth, as in juvenile youth, and apparently it is not case sensitive. So those of you seeking CLE credit, as I am, that is the first code word. Okay, so I think we come next to Professor Henning.
Excellent. Thank you all so much for having me. And it's an honor to be on with, Okay, great. Can you all see me? See my slides here. It's an honor to be on the same panel with these wonderful folks, Professor Hyatt, Professor Joe, going before me has been excellent. So let me get myself up in presenter view and we will be good to go. Can you see just my slides with no notes?
Yes.
Excellent. Beautiful, beautiful. So I love that the code word was youth because that's where we're going next. So it's kind of timely. So look, as Professor Chen said right at the beginning in our introductions, I teach the Juvenile Justice Clinic at Georgetown Law. And I have been representing children in the District of Columbia for the last 26 years. And I have to say that in 26 years, I have represented only 4 white clients, 4, all right? So my 99% ratio would lead you to believe that I live in a city that is predominantly Black or that no white children commit crimes. Neither of these facts would be true, or neither of these propositions would be true. And so this extreme disparity has really forced me to think about and to write about the role of prosecutors and other stakeholders, but particularly prosecutors in the juvenile legal system. And so I want to start my remarks with the following 2 propositions. The first is that the mass incarceration that Professor Joe talked about, the mass incarceration of Black America begins with the criminalization of Black children. The second proposition is we do not see Black children as children, and that affects every single decision that is made in the system, including those decisions made by prosecutors. And so what do I mean by the criminalization of Black adolescents? I argue that criminalization, and I think we know, I don't have to argue this, criminalization of Black adolescents operates at multiple levels throughout every stage of the system. But for sake of time today, I'm going to focus on just 2 stages. First, it is the criminalization of normal adolescent behaviors in school, in the community, in recreation centers, by the police, by civilians, on the street, in labeling folks gangs, Professor Hyatt, right? All of that involves normal adolescent behavior. And the second dimension is on the back end of the system and looking at the dehumanization of Black children at the sentencing phase. So when I talk about normal adolescent behaviors, you all know that I am talking about all those things that kids do just because they're kids. Using drugs, getting into fights, being rude, disrespectful, talking back to teachers and other adult authority figures, right? And these adolescent behaviors occur all over the world. Research shows that teenagers act like teenagers wherever they live and whatever they look like. Youth of all races, all classes, and all ethnicities experience the same key features of adolescence that if I asked you in a call and response to tell me, you could all tell me. Teenagers are emotional, reactive, sensation seekers, they're impulsive, they care way more about the immediate rewards than the long-term consequences, they take risks, and you know that they often make bad decisions and are really bad strategic thinkers, right? But what else do we know about young people? We also know that young people are resilient, right? And as they transition into adulthood, they eventually develop the skills they need to process information and to make better decisions and to control their behaviors and their emotions. In fact, reckless behavior is so common among adolescents that it is literally considered a normal characteristics of adolescent or of the adolescent years, of the teenage years. But few young people, very few young people go on to become what they call life course persistent criminal offenders as adults. And the research, the data shows that the incidence of both minor delinquency and more serious violent crimes peak in adolescence, but drop significantly and rapidly by the time they reach young adulthood. Most children age out, naturally age out of delinquent behavior by late adolescence with no intervention whatsoever by the courts or by anyone else. Now, this is a conversation about race and the criminal legal system and prosecutors. Despite everything that we know about adolescent development, and despite the fact that there is unequivocal evidence that adolescence looks the same across race and across class, we all know that Black youth are treated more harshly than white youth at every single stage of the juvenile legal system. So in 2008, for example, the data shows that Black youth accounted for 35% of all arrests, youth arrests for crime in that year. It accounted for 40% of all cases in which the young person was sent to a detention facility to await sentencing. It accounted for 39%, Black youth accounted for 39% of all cases formally processed in juvenile court. In other words, prosecuted, right, by prosecutors. 51% of youth whom a judge referred from juvenile court to be tried as an adult, and 41% of all cases in which a youth was placed in secure or non-secure residential facilities. And so let me be clear that prosecutors play a role in every single one of those actions, direct role in every single one of those actions on my last slide, except for arrest. And my argument is that they play an indirect role, even in disparities at arrest, because they are the gatekeepers. If they refuse to prosecute what police officers brought in the door, we would stop that. Instead, what we see here, and I'm sorry for the pictures coming in, trying to make it interesting, but look, we know that young people are prosecuted for the most normal adolescent routine behaviors: disturbing schools, disorderly conduct, wearing sagging pants, drug offenses, experimenting with drugs. I won't ask you how many of you experimented with drugs as a teenager, right? What they call sexting now. In other words, flirting with classmates in sexual overtones by way of your text, participating in political protest, and again, being labeled as having your friendships, your normal friendships labeled as a gang, right? Now, sure, every one of these, putting gangs aside for a second, every one of these is technically a crime. And so they technically can be charged by prosecutors, but they also involve normal adolescent behavior that can be managed at home, school, or in the community. And so the question is, do these behaviors need to be prosecuted by the court? Or in a court. And so everything I talked about on the last slide is really a low-level misdemeanor that didn't need any intervention at all. But I'm going to press us just a little bit further to think about the role prosecutors play in what appear to be even more serious offenses, right? So let's consider the following examples from one of my cases in the clinic. So we represented a girl, Sharice, 17 years old. She had been dating Mike off and on for about a year. Mike and Sharice were typical adolescents. They got along half the time. They argued half the time. And Sharice also struggled with a learning disability and emotional distress, which caused her to overreact sometimes. So one day, Sharice was convinced that Mike was cheating on her. So Sharice grabbed Mike's phone, began to walk down the hall and scroll through his text messages to see who he had been texting with. All right. The school resource officer observed the entire interchange and stepped in to intervene. Well, what was his intervention? To arrest her. All right. So we're talking about prosecutors today. We'll leave the SRO alone. That's another lecture, right? Another conversation. But let's talk about what the prosecutors did. The prosecutors prosecuted that, right? They brought that. And not only did they prosecute it, they prosecuted it as a felony robbery, taking property without right. I also want to press us to think about how many normal adolescent behaviors escalate into more serious behaviors when police officers show up. All right. So consider this example. Another young man we represented, James, 15-year-old boy who was wearing a hoodie sweatshirt in public, which in the District of Columbia, believe it or not, was a violation of this obscure city ordinance that prohibited people from wearing a head covering or hoodies in public. I should just, as a side note, tell you that the statute was designed as a regulatory provision for the KKK marches, but yet they were using the statutes to prosecute young Black boys. So the officer walks up to our client, James. He asks him to take it off. What does James do? He acts like a teenager. He's like, "You've got to be kidding me. No, I'm not doing it." Officer reaches out, snatches the hat off of James's head. It turns into a tussle. What happens? He gets arrested and the prosecutors charge him. And we went to trial on a felony assault on a police officer because of this, dare I say, foolishness. All right. So, James was reacting like a normal teenager, impulsive, reactive. He cares a lot about what his friends see. The friends were watching. And although he was inexperienced in the law, he knew injustice when he saw it. And so then what happens when children talk back to the police and they're outraged? They get arrested again for being rude, giving attitude, failing to comply with police. And they get charged by prosecutors with resisting arrest, threats, and assault on a police officer. And my point here is prosecutors, we've heard this word today, prosecutors have discretion not to pursue these types of offenses, all right? Not only because they're normal adolescent behaviors that don't warrant intervention, but also as a check on police powers, right? Prosecutors are the most powerful people in the system, and they can hold others accountable. All right, that's the front end of the system. That's just part of the front end of the system. And then let's move to the back end of the system and look at the dehumanization of Black children at sentencing. So until very recently, youth who committed crimes were held to the same standard of culpability and punishment as adults. But in a series of cases over the last 15 years or so, the Supreme Court has finally begun to catch up with the rest of the world in accepting what we know about adolescent development and recognizing that it is cruel and unusual punishment to execute children and sentence them to the most serious offenses. But you know where I'm going next. Even as we are coming around to a developmentally appropriate response to adolescent offending, data shows that Black youth do not get the same mitigating benefits of adolescent development. Black youth are incarcerated in adult prisons with adult offenders. They are subjected to the most severe sentences like juvenile life without parole, at much higher rates than white youth. And this is not you. We are still seeing the residual effects of the 1990 super predator myth, when Black youth were demonized by the media and conservative politicians who framed and exaggerated the crime problem as primarily a poor Black male problem. Black youth became the principal targets on the war on crime, the war on drugs, and when states began to respond with legislative reforms, Black youth prosecutors and judges were transferring more Black children to adult courts at younger ages for more offenses and for longer periods of time. And so if you look at my chart here, you can see how the racial disparities between Black and white youth sentenced to juvenile life without parole were evident since the 1980s, when these statutes were first introduced into the criminal law. And then they continued to grow between 1980 and 2013. So by the time we got to 2016, which is off my chart, I'll get to in a second, more than twice as many Black children were serving juvenile life without parole sentences than white youth. And even as life without parole sentences have been declining rapidly in the United States after the Supreme Court cases, racial disparities have actually been increasing. So for example, between 2005 and 2018, you can see a rapid increase. In 2005, 39% of the cases transferred to adult court involved Black children. In 2018, Black youth made up over 51% of these transfers. And so today, about 50% of all people serving juvenile life without parole sentences for a crime they committed when they were a child are African American children. All right, and so why do these disparities persist, even though you no longer hear folks talking explicitly about the Black super predator child? Well, research shows that, among other things, implicit bias affects the way all of us, including prosecutors, think about this really important question about culpability and about punishment of adolescents. So in one of the most fascinating studies, I think, on implicit racial bias in the juvenile and criminal legal system, participants were asked to read factual information about a brutal crime, specifically about a 14-year-old male with 17 prior convictions who brutally raped a woman, an elderly woman. And the participants, the researchers, manipulated one word in the fact pattern. For some participants, the youth was described as a Black male. And for other participants, the youth was described as a white male. You can imagine what the findings were. When participants were led to believe that the youth in their little fact pattern were African American, they were more likely to support juvenile life without parole sentences as a general policy matter, not just in that case, but as a policy matter. And they were less likely to believe, explicitly less likely to believe, that young people should be treated as less culpable and as less blameworthy than adults. So in other words, they explicitly decided that they were not entitled to mitigating benefits of adolescence. But if they thought that the child was a white child, then as a matter of policy, oh yes, we have to treat children differently. So it's a really profound effect. So I want to just, close us out with a few words about, so then what do we do about it, right? Picking up where Professor Hyatt, got us to thinking about, so what are prosecutors supposed to be doing about it? So one of the resources for those of you who are interested, the Fair and Just Prosecution put out 21 principles for the 21st century prosecutor. And in that, they included some very definitive statements about how to respond to youth and adolescents who are referred to the system. Number one, which is the most important one, is treat kids like kids. That's where they started, right? Don't prosecute kids for typical adolescent behaviors. That's how they framed it. Don't seek detention when a young person can be supervised in the community. Don't seek to try young people in adult courts, right? Pursue lesser included offenses rather than a felony. So in my cases, both of the cases in which the Sharice was charged with robbery for snatching her boyfriend's cell phone, why was that, first of all, why was it prosecuted at all? But why was it a felony? Right? So that's the thing you have to think about. And then don't seek juvenile life without parole sentences, period, for offenses that were committed before the age of 18. So prosecutors have a definitive role. In addition, at the front end, treating kids like kids means that prosecutors should adopt charging standards that reflect the current research on adolescent development to ensure that the mitigating approach to teenage offending is applied equitably across socioeconomic and ethnic groups. And so just as just one example of that, the National District Attorneys Association has charging standards that have very little reference to young people, but they do have a section, and that section is woefully inadequate to the task at hand. So most states and the National District Attorneys Association, if they have charging standards at all, they say that charging decisions should be made based upon the nature of the offense, whether there was violence and bodily injury. And what they don't do is include commentary on adolescent development and racial bias. And so that's what has got to happen, training and appropriate standards that get at this. So let me just say my last two slides are this. One, prosecutors must really understand the harms of detention and the harms of transferring young people to adult court, including and especially those harms on African-American children. We know that young people in these facilities experience physical violence, sexual violence, loss of education, loss of contact with family and friends, and so much more in detention facilities. And we know that treating children like children means that they have to recognize and understand the ways in which implicit racial bias and explicit bias distorts our perspectives on adolescents, culpability, and punishment throughout the entire stage of the case. So I'm happy to talk more about solutions when we go to Q&A. Thank you very much.
Thank you so much, Professor Hanning. And now, finally, but by no means no less emphatically from the perspective of a former prosecutor, Mr. Oduye, please.
Yes, good afternoon. What I want to do first, I know there's been a lot of conversation, give people a moment to stretch and take their eyes off the camera, because I understand, we live in a Zoom world and, people need to stretch. So I'm going to give you guys a moment to stretch out, take your eyes off the camera, because you heard a lot of good information, but sometimes you just need to get your body moving a little bit. Next, I hope everyone got a good stretch in. Next, I'm gonna just basically give a background of myself. I was a prosecutor for 12 years in the Los Angeles County District Attorney's Office. I've done, number of cases in terms of trials, thousands of preliminary hearings. I've been all over the county of Los Angeles, and it's been an interesting ride when I was there. I don't have a PowerPoint presentation, and I didn't teach. I wanted to say I teach at No Town University because I don't teach. But what I do have is a particular perspective from the viewpoint of a progressive Black male prosecutor in one of the largest offices in the nation. And what I did was, right after the death of, or the murder of George Floyd, I wrote a series of articles on Medium under anonymous name named Spooky Brown Esquire to talk about these experiences that I had as a prosecutor, because I felt it was relevant to the conversation of what progressive prosecuting should be like and what happens when progressives encounter a system that is emphatically racist and oppressive and not good at all. And so I wrote a series of articles under the pseudonym while I was still in the office. And it created and generated a lot of buzz because people wanted, in my office, wanted to find out who wrote it. And it wasn't because the stuff was true or not, it was because it was during an election season. And I think there was reference to the election of George Gascon, who defeated the predecessor of Jackie Lacey. And, you know, that kind of added to the whole buzz. So what I'm gonna do, instead of doing a PowerPoint, I'm just gonna read a little excerpt from the article that I wrote, or part one of the article that I wrote. And it's entitled, Why I Don't Trust Prosecutors. And this is on Medium. It's not that long. So the first title is, Who Am I? I'm a man, I am Black, I am also a prosecutor. I work for one of the largest and most powerful agencies in the United States, the Los Angeles District Attorney's Office. With over 1,000 attorneys and 300 investigators, my office exercises jurisdiction over 10 million people in 88 cities within the county of Los Angeles. That includes the well-known cities of Beverly Hills, Compton, Long Beach, Los Angeles, and Pasadena. We decide who gets charged with the crime, whether that charge is a misdemeanor or a felony, and how much time will be served. We decide who goes to state prison and who goes to local county jail and who gets probation. We also decide who gets to live and who via the death penalty gets to die. As a line prosecutor, I'm required to follow the decisions that my supervisors make about people who are charged with crimes. Most of the time, my supervisors have been white and the people charged have been Black and brown. While some of those decisions have been right, too many of them have been wrong, dead wrong. I'm going to talk about some of the wrong ones. Why? Because they reveal just how fucked up the criminal justice system is. They reveal how racist and oppressive many of our decisions are, and they reveal how much we as prosecutors abuse our power knowing that the people we fuck over are unlikely to fight back. The stories I'm about to share are based on shit that actually happened. And this is the excerpt about the first felony case, and I'll just give a brief excerpt about that. And it's entitled, The First Case for a Baby Prosecutor. Hey, don't fuck up this trial. I was sitting at my desk preparing for a suspended driver's license jury trial when my white supervisor said those words to me. He had a deadpan look on his face when he handed me the case file, but left with a grin. This was my first felony jury trial. As a new baby prosecutor, getting a felony trial meant someone believed that I was ready for the big leagues. I was being called up from the minor leagues of low-level misdemeanors and moved up to handling cases that mattered. I opened the case file and read the summary of facts. Byron, a 20-year-old Black man, was pulled over by two Hispanic police officers after failing to signal when making a right turn. He became upset after the officers ordered him out of the vehicle. When he refused, the police forcefully removed him from his car. A physical fight ensued with one of the officers, and after he was arrested, the officers discovered that he was on felony probation and thus subject to police searches at any time and at any place. And as a result, the officers looked to him or went to his home where he lived with his mother. And while searching the home, the officers found a gun underneath a couch where he regularly slept. As a felon, he wasn't legally allowed to own guns, and he was charged with felony arrest, resisting arrest, and illegal possession of a firearm. Because of his strike prior, Byron faced a maximum of 7 years in state prison. He rejected the previous offer of 6 years. Since Byron fought a policeman, the offer was way higher than the norm. He would have received no further time if he had it. And if you fuck with the cops, the district attorney will fuck with you. And that was the unwritten rule in my office. And after reading through the police reports, I was very concerned about the initial traffic stop because I knew the drill. I'd been unjustly pulled over by police officers several times, even as a prosecutor. Still, I felt a little more comfortable going forward because a judge had previously ruled that the stop was justified, denying Byron's legal challenge. I was ready to dig in and prepare for trial, especially since it was set to start in less than 20 or 48 hours. So I'm going to stop there. And if you want to know more, you want to learn more what happened, we can talk about it in the discussion, or you can read the articles. But I really want to get into the meat of discussions about the roles of prosecutors, because I think it's very important to have that conversation, especially from, you know, the distinguished panelists right here and myself and my perspective and the things I've seen and the things I've done. So I'll stop there. Thank you.
Thank you so much, Mr. Adie. So now we come, actually, we have maybe a bit more time for the Q&A. Let me ask this, since we have a few extra minutes. Let me ask, I know I'm springing this on you, but I just thought of it. Before we go, we have some questions that have appeared in the Q&A. Let me ask, are there any questions that members of the panel might want to ask to any other member of the panel?
Yes, I would.
Professor Hyatt, and to whom are you directing your question? Or is it
I want to ask Mr. Awaye, can you pronounce it for me so I make sure I get it right?
It's Adewale Oduye.
Adewale. Perfect. I wanted to ask him, because I have read a lot of the things that you've written and I see that you describe yourself as a progressive prosecutor for 12 years. And I want to know, like, what, I guess, what are your receipts? You know, what gives you that title to say for 12 years I engaged in what could be considered progressive, especially knowing that Jackie Lacey, who all of the problems that she caused at the top of your office, how you were able to like develop yourself as a progressive prosecutor within that space, and the kind of things that you did to demonstrate that.
Well, I think the whole idea is about discretion and using discretion to make decisions. I mean, I think individual prosecutors have a wide range of discretion in how we file cases, how we try cases, and how we proceed with cases. And my whole goal in doing the job was to do the job in the best interest of justice. So that meant not filing a case because it wasn't evidence, even though police officers feel otherwise, or not proceeding on a case because it appears that cops or officers lied on a case, or go to my supervisor and make the request that a case be dismissed right before trial because there's not enough evidence to pursue it, or going to the crime scene myself to do my own investigation to see if a case could be proven beyond a reasonable doubt, or making the decision in terms of time, right? Because a lot of times, just because someone is eligible for 35 years to life or 100 years to life doesn't mean that that's what the case is worth, in my opinion. So it's a matter of figuring out what the system, navigating the system in a way that is just and gives people a little more confidence in the system as a Black male prosecutor. And, you know, for 12 years, that's what I felt I did. You know, and I'm not going to lie to you and tell you that it's been easy. And, you know, you definitely have to make choices in regards to your own professional movement or your own professional upliftment and staying true to the cases that you have. And I've chose the latter because, you know, to me, I'd rather do right than get promoted, or I'd rather do right than, you know, do something that doesn't ethically sit well with me.
So maybe I could follow up on that, Adewale, if you don't mind. So, because I also know many line prosecutors, right? Frontline prosecutors who make decisions or who are thoughtful in the ways in which you describe you're handling your own individual cases. And I guess my question is, to what extent So one, to what extent is your front office or the leadership in your office amenable to that type of prosecution on the front line? And that's one question. And I guess the second question is, what can like-minded line prosecutors do to hold leadership in their office accountable for the values that you espouse?
I think what a lot of people don't realize is that everything is really trickles down to the line DAs. And so say for instance, even if management had a certain idea of what they wanted to do or what philosophies they wanted to set, it may or may not trickle down to the individual supervisors and to the individual DAs. So I think for me, it was always about doing the extra work that needed to be done to justify a result to a supervisor, even if I knew that that supervisor either didn't align with what management said, or did some things that was in line but wasn't, I guess, congruent with what justice requires. And I think, as I said before, a DA, an individual DA, has a lot of discretion. And I would say the most problematic thing that I see as a DA, at least in my position, was the idea of doing trials and doing as many trials as possible, which I never espoused to, and getting a certain number of convictions, right? So basically, when you are a DA, right, the way you get promoted, at least before Gascon, was by the number of trials you did generally, right? That was the idea, is how many trials you did. And if you go through a database in the DA's office, you can type in your name and your ID, and the amount of trials you have comes up along with your conviction rate. And so I know that there's been discussions in relation to people and how they get promoted is, if you are tied, say if I had 30 trials and someone else had 30, a lot of times the way in which that, you would decide who would get promoted would be based upon a conviction rate. And what that did was it created a perverse system, right? Because you had people who had cases that were easily proven, but instead of giving an offer that was fair or legitimate, you would raise the offer to force the defense to go to trial, because you not only wanted the trial statistic, but you also wanted the trial conviction. And that's what I saw in a lot of situations. And I actually broached that to Lacey several times personally, because I didn't feel that kind of incentive was in the interest of justice, particularly in a lot of cases involving gangs, right? Because a lot of people don't want to testify when it comes to gang cases because of some implications. And my whole goal when I deal with victims is I tell them, my goal is for you to never testify. That's my goal. Because I personally understand, growing up in Brooklyn, New York, what are the implications in a lot of cases or similar cases. So if I can get a fair disposition that doesn't require people to testify, then that's what I'm going to do. And while that may affect my stats trial-wise, ethically, that is the right thing to do. And I always sided on that, right? It was never about stats, and it never factored into me. And I told people about that. I told them, in terms of victims and witnesses, how we are judged and how my role or my job is not to get the trial stat, but to make sure that you are safe, number one, and number two, a just outcome comes available. And I tell that to defendants and or incarcerated or accused. I tell that to the accused, and I tell that to the accused family as well. And I think as part about being a progressive prosecutor is you have to think about everybody. It's not only about the conviction, but it's about doing justice to make sure everyone gets a fair shake. That includes the accused as well.
Can I interject a little bit, because I wanted to push back on a couple things that you just highlighted. Number one, the concept that fairness somehow comes out by witnesses not being required to testify, as opposed to this concept that, the question of guilt isn't something that the prosecutor is really in a position to decide based on their personal assessment of witnesses, and the Sixth Amendment that allows a defendant to have a fair trial and not being punished because they want to exercise their right to a fair trial. And then secondarily, I want to just push back on this concept of being able to label oneself as a progressive prosecutor, when like the truth of the matter is that really going back to the beginning of my presentation, that yes, I think some of the decisions that you're highlighting are some good, that you are impacting some individuals and making some good decisions. But I think that this concept that everybody can call themselves progressive because they've done some good is a misnomer, to say the least, but certainly it really is destructive to this concept of real fundamental change. That we can't expect fundamental change if that this title doesn't mean anything other than, you know, I tried to do what I did nicely, as opposed that I tried to upend the system. Because to be progressive is more than just simply not being racist, because you don't have to be racist to participate in a racist institution. We all do it because, you know, we all benefit from the supremacy and our privileges and so on and so forth. But how do we reject it and upend it? And you know, my request is for, if we're going to label ourselves as progressive, to do more than just simply say that, you know, I was there and I wasn't as bad as the next guy, or sometimes I tried to make the right decision. I don't think that that is progressive, and looking at our own true histories to assess that.
I mean, I agree with you to an extent, but I think, you know, part of progressive is an evolution, right? So Gascon would be considered a progressive prosecutor, right? Marilyn Mosby would be considered a progressive prosecutor because systematically you're trying to implement policies that make the system more fair or have the impact lessen as to, you know, people who have been accused of crimes. I mean, you don't know who I am. You don't know me. I haven't talked to you, you know? And so I think your criticism is fair based upon that. But in terms of what I did or what I do on a daily basis, you know, the idea of being able to do the right thing at the right time, despite the challenges that are faced, you know, that's what I would label myself, right? And you know, that's subject to criticism, that's subject to argument, but that's something that I've always held on to way before, you know, we started talking about way before progressiveness became the vogue thing to do or say.
So why don't we go to some of the questions from our audience, and there are quite a few of them, and I beg your indulgence at the beginning. I will try to get through as many as we can. I may, if I see some questions are somewhat similar, I may try to merge them. So the first one, citing writer Freddie DeBoer, notes that there is a concern sometimes about getting too far ahead of the rest of the community who may not have yet processed the same information or come to the same conclusions. And related to that, the actual question is the effort to recall recently elected and reform-minded LA DA George Gascon, just months after he was elected, a sign, I guess, of that syndrome, and how do advocates for anti-racist prosecutorial systems increase the purchase, I guess, the ownership of the idea for anti-racist reforms in the community?
I'll give a quick, I've been pushing back at my friends and colleagues who have, like, people who I love and care for, posting things like, did you see that he's not seeking a death penalty on this guy who killed the cop? Well, number one, the guy ain't been convicted of killing the cop yet. But number two, like, we know the death penalty is racist. It's been proven up, and he said that's what he was going to do, was not seek the death penalty. So we need to support that. And similarly, a young man charged with killing 2 young girls in Los Angeles. Like, did you see he's not going to charge them as an adult? Well, we know that children are children no matter what crime they committed. And he said he wasn't going to charge them as adults. So we got to have some uncomfortable conversations with our friends and family, that we don't go for the Willie Horton approach of scaring us into mass incarceration and thinking that this penal and punitive approach is the answer.
Yeah, I really want to underscore
agree.
that. Yeah, sorry.
Go ahead, Professor Hanning, go ahead.
I really want to agree. And I'll take the sort of the first half of this question, this notion of getting too far ahead of the community. It is absolutely true that, for example, Black communities who are the principal targets of these discriminatory criminal justice actions are not a monolithic community. And so, as Professor Hyatt said, we've got to figure out how to have, call out our friends and family who don't understand. And so the way it materializes in the work that I do is I really am working hard to educate the entire community, Black, white, blue, green, on the traumatic effects of policing on, for example, adolescent development. The problem is, understandably, a Black grandmother will say, but I want my community safe. I want the kids off the street, drinking and playing their music too loud, right? But we act like it is a one for all solution, and that the only way we can achieve that for the Black grandmother is to lock up the grandson. And that's not what she's asking for. If you would provide her with a reasonable alternative and provide the young people with a reasonable alternative, jobs, better schools, reasons to occupy them or activities to occupy them, then they don't have to be out there. Grandma didn't ask you to go lock my child up in the jail. So I think there is an education of all of us, Black and white, of the harms of the system, and then to recognize that, when somebody says, I want help, they're not screaming for you to come, with an axe to chop everybody down. So.
Yeah, I won't speak too long on this question because I know you want to move on to others, but I just wanted to say really quickly, one thing that we might consider doing that I think would help move things along further is really emphasizing the data we have out there to suggest that a lot of these decisions are actually more harmful than they are helpful. Maybe that's just the professor in me, the academic in me, but I think numbers can really move people's emotions to a degree.
And I just wanted to add, I think that is fair to say, but I think the stories that come out on cases and real life experiences, I think is what can really move people. And also the statistic, at least in the state of California, is that overwhelming majority of crime is non-serious and non-violent, right? So when you have that idea and when you have that statistic and you see the disproportionate nature of how Black and brown people are affected by the criminal justice system, it has to force you to reevaluate what you do. Because I used to work in the white collar crime division, right? Where none of the people accused were Black or brown, right? They were white for the most part. And there's already been reform in that space. Enhancements have been eliminated in that space a year before Gascon came into office, but no one talks about that. So there's way more disparities in the conversations that we have, and it falls disproportionately on Black and brown people, particularly if you take into account that majority of crimes are non-serious and non-violent.
We have a question that I think is probably directed to Professor Hyatt. So disheartening the gang statutes are designed and used in this way. Here's the question: has bifurcation, as you just come, been utilized anywhere as a policy yet, or have you or anyone advocated for bifurcation even when it is not a policy?
Yes, bifurcation has been used. New Mexico actually bifurcates the gang charge, and on the prosecution, you have to file a motion and argue it. And in the criminal law, we have a basis to essentially bifurcate. It's called severance in the criminal law. We can ask for prejudicial evidence to be moved to the side, and my client may be charged with being a possession and felon in possession of a gun, and I can bifurcate or sever certain evidence to not come in that case. So it is something that is used. And again, we have a constitutional basis. We have the United States Supreme Court saying that prejudicial evidence that overwhelms a jury should be separated. I have, in the gang cases in which I've litigated, I have filed motions. The problem is, again, the statute requires proof of the gang evidence, and the substantive crime. So what I realize is that the people who further mass incarceration write these statutes to effectively have us all participating in their goal. And then next thing you know, a guy who you have no evidence on a substantive crime on is guilty because people in their particular neighborhood have committed crimes that are provable.
As I was telling Professor Hyatt and the rest of the panelists before we began, I must confess, although I'd heard of gang criminality, I never really, I was motivated to go look at New Jersey's definition of gang criminality, and I got to admit, I still don't know if I can make heads or tails out of it. So my follow-up question on this is, has a gang criminality ever been challenged, either on First Amendment grounds? Because some of New Jersey says you have to show 2 out of 7 criteria, some of which, I mean, it could be construed as completely innocent or expected, or as Professor Henning put it, normally expected behavior from adolescents. Has there ever been a challenge that wearing certain colors combined with a tattoo, that's 2 factors, now you're in a gang?
Well, it has been challenged in the abstract. You have Dawson, where a white supremacist, they wanted to submit his gang evidence, and the Supreme Court said, no, he has a First Amendment right to have all his gang tattoos, and you're not going to allow these gang tattoos to be seen by the jury. And that's in a white supremacist context. He was charged with another crime. They wanted to use the gang. But they have been challenged in terms of these gang injunctions. And that's what the statutes emerged from, that you had gang injunctions just were essentially like quintessential badge of slavery. Let's get you off the street and round you up because we don't want you standing around on the street. So that's when they added the predicate act. So they're very effectively written to try to get around constitutional principles, and the Supreme Court has not taken on the challenge yet, in gangs in particular.
Let me take this opportunity to mention and give you all what I know you've all been waiting for, the second CLE code word to certify your attendance for this session, and the word is future. Future, again, not case sensitive. So let's try another question. We have one question here. It's a bit New Jersey specific, but I'll ask it anyway, since the trend is nationwide. What is your opinion on the impact of bail reform in New Jersey? I mean, in New Jersey, in the past few years, I don't know if you know, but certainly there are similar measures across the state, has basically done away with cash bail and has significantly reduced the amount of pre-trial detainees, but it certainly has not eliminated them. The questioner, it goes on to say, many people voted to end monetary bail because of stories like Khalif Browder. I haven't done a ton of criminal cases, obviously this is a lawyer, but following the headlines and organizing efforts in the states, it seems like bail decision guidelines still keep people incarcerated unnecessarily. What is your opinion on the success or lack of success of bail reform, and what can prosecutors or judges or regular attorneys do? And I suppose I will add that, consistent with the theme of this, do you think that bail reform is in New Jersey, but in other states as well, is doing anything to remove the racist outcomes that we get from our criminal justice system? Does it ameliorate it significantly? Any?
I'm happy to jump in. So it's I am excited by the attention that's being paid to bail recently. I am disheartened and worried about the conversations about what's going to replace those systems and the process of making decisions. One particular one that I discussed with my students just the other day in our criminal procedure class are the risk algorithms that are out there, right? That are presented as these sort of objective measures of whether or not somebody should be, held pre-trial, predisposition of case, when they're actually not objective, right? The questions that you put into those systems, the designers and developers of the systems, they are all operating from places we all are as human beings, people that exist in this nation with its sordid history of racial dynamics, of acting with bias, both explicit and implicit. And the idea that we can introduce these sort of algorithms and all of a sudden everything is fine, I think is just sort of, to sort of borrow a word from Professor Henning, just foolishness that we need to address.
I would also add that we could take a step before that and, like, you know, be prior to the 1980s, this concept of holding a person in jail because they may have a future dangerousness was just ridiculous. And then we passed the Bail Reform Act. And when it was challenged, you know, you had the Supreme Court saying like future dangerousness is okay. And Thurgood Marshall, you know, screamed out like there is no legitimacy to say a person who's not convicted of a crime that we can hold because they may commit a crime in the future. And if you do a little research on the back end, you have Justice Rehnquist in his opinion saying, well, the Congress is asking for us to make these changes in the Bail Reform Act. And he cites a committee note. If you click on that committee note in the opinion, you're going to get to Congress's acts and what Congress says, and this was mind blowing. Congress says, we're responding to the Chief Justice asking us to do this. So when you talk about like, you know, the pulling of the strings, you have like, you know, people who want to hold you in jail without even convicting you, telling Congress, let's pass laws to hold them in jail without conviction. No, there's no constitutional basis for that. There's not like, there's no, like we have one is entitled to bail. And then we have the Supreme Court say, well, it's really reasonable bail, not bail. So like these concepts from their inception are about mass incarceration. They're about the prison industrial complex. You have the Supreme Court in that era literally making more ways to keep people in jail. And the last note I'll say on that, when in that case, the individual that they extended the hold to had already been convicted of a murder and was serving a life sentence when they extended the ability to hold him. So it wasn't even necessary. It was a moot issue at the time. So we have to acknowledge that it's illegitimate from its inception.
I think I'm merging a few questions, and I hope the individual questioners will recognize the theme. And I suppose this might go to Mr. Oduye in the first instance, but the sense is, I mean, how can an individual prosecutor, an individual progressive prosecutor, how effective can it be if the overall culture of the office is to, frankly, reward convictions, even those that were probably prosecutions that shouldn't have been made? And I'll throw into that, does a progressive prosecutor develop a reputation to the point where your ability to interact, your relationship with law enforcement is affected to get cooperation in that area? So I guess does there come a time when one individual is not able to fight the entire systemic, particularly the systemic racism that occurs in the criminal justice system?
I mean, I want to emphasize that you do need systemic reform or systemic change, however you want to phrase it. But I will say that, you know, cases involve individuals. Like we can talk about general statistics all day, but individuals whose lives are adversely impacted, that makes a difference in some way, shape, or form. So for me, you know, I understood the culture, and it was pointed out how the DA's union, you know, sued, you know, Gascon for a lot of the enhancements that he had to show the culture, you know, but, you know, being able to work within the system to get a just outcome by any means is something that I stood by. And there's different varying ways you can do it, especially if you disagree with a supervisor's direction. And we could talk about that at a later time, but I think systemically, no, right? But I think for me, it was all about the individuals and the individual cases and doing right by those individuals to make sure that some semblance of justice happened. It's not perfect, it's not the best outcome, or it's not perfect, but to me, it was about the individuals.
I just, you know, and I've been debating on that, I say this, but I'm just having a difficult time of keep like suggesting as if you can truly be progressive as a line prosecutor. Like you, meaning you can make some good decisions and you can do some things, but like in order to keep your job, and as you've described and you provide the framework, in order to keep your job in advance, you really have to like do your job and lock some people up. And what that really means is that, you know, making most of your decisions will be a reinforcement of something that is fundamentally flawed, that you're going to seek robbery convictions when you can seek thefts, or you're going to get in attempt to get evidence in that will enhance the possibility of a conviction, or you're going to say things in closing that you know are inappropriate and that the judge may hold you accountable for, but at the same time, you're going to say it because you want to get that conviction. So to like continue to suggest that, hey, I can individually do what is right, when we know when we're having hundreds and thousands of cases on a daily basis, we're mostly doing that which is wrong. And we just have to acknowledge that in order to make real change. That in order, like, we are here to do bad work. And within that, I'm going to try to do some good. But I think to somehow suggest that I can be moral, I can be ethical, and I can do it on a daily basis is not in line with our reality of having hundreds of cases.
And that's where, and that's where I disagree. And that's why I said in terms of, at least, and I'll say in LA County, first of all, there's job security, right? You cannot be fired as a DA unless you do something totally egregious, which is why the union is doing what they're doing, because they know they have job security, they can't be fired. So, but I think because of the amount of discretion that we have as individual prosecutors, that you can do something in relation to the cases that you influence and the cases that you personally are assigned to. And over the course of my time as a prosecutor, I'm assigned thousands of cases where, you know, in terms of individuals has made a difference. And I'm not going to argue with you in terms of systemic. I agree with you. You know, the change has to come systemically, but to say that there can't be an ethical prosecutor within this system, I disagree with, respectfully.
So could I dare to weigh in this, which is interesting, and really, because it's the maybe the mediator in me, the teacher in me, something's happening listening to the polarization of the debate, because I actually want to say both and, right? Like I agree with what both of you are saying legitimately. And for me, so what I hear Professor Hyatt saying is fundamentally with the language, the use of the language progressive as among other things, right? You know, the substance of being moral and ethical in those roles. But if we start with the language, I think I am not as bothered by the use of the word progressive. I agree that it is much harder to have weight and power and force at the line level, but their language has meaning. Right. And so for him to, you know, to be able to stand up and say, I am a progressive prosecutor, even if my colleagues look at me awry, or even if my supervisor looks at me awry or punishes me in small ways, I am saying something and I am making meaning on behalf of Black and brown people in the system. And so I want people to claim that title and to do whatever they can with it at whatever power place that they hold within the system. And so I want to say both and. Secondly, I agree, and I said this earlier, like it's the leadership that has got to make a change. And I don't want you to hide behind a label and allow that to not let you as line prosecutor to gang up with other line progressive prosecutor and really storm the front door and say, we're going to make systemic change. Because I think you can make systemic change in numbers and in voice and in volume. And if all of you, I don't want you to get fired, but if, you know, I know you don't work there now, but if all of you got fired together, you better believe there would be media attention, right? Show up and show out and you make change. So I don't buy, so that's why I say it's a both and. I don't buy that line prosecutors can't make more reform if you fight harder, but I honor what you're doing even at the line level. And it may be just as a defense attorney, I love it when, you know, I can't speak too much because I know this will be on video, but when my line find prosecutors in DC, use, for lack of a better word, subterfuge, right? Like their bosses won't let them dismiss the case, and they figure out ways to make it happen, right? So there is power on that front line. So I just wanted to say both and, if I might.
Thanks,
And
Fred.
I'll just add one last thing, because I absolutely agree. I think what the challenge is that there's sacrifice that comes with that, and that it's in many ways a dangerous position. But as a prosecutor, when you're supporting concepts of individuals, of putting them on probation and saying, and being quoted in newspapers saying, I'm going to hold their foot to the fire, meaning that I'm going to have every hurdle for them to violate that probation, you're becoming a tool. When you are in opinions of your high court of the state of California, when a high court is saying on 3 occasions, there's been ethical violations, and white supremacy says, yes, there's ethical violations, but we're going to still confirm this conviction because his lawyer was inadequate and did not object. And, so to know that, and that's just one case. So to know that cases like that exist, when you're in the trenches of doing this work, you're gonna cross over many times, because that's what it requires you to do. It requires you to take that slave back to its master and be a participant in furthering slavery, even if you don't want them to be raped and maimed in the process. And I just think that acknowledgement is important, but I appreciate all of the comments.
There are a few questions that speak about the use of the ethical rules to improve, to affect change in the prosecutor's office. So I'll direct a general question to Professor Joe. First, are there any examples or templates in which the ethical rules, the RPCs, have been used to affect systemic change? And I will throw in just that. I'll throw an example from my own personal experience. As I mentioned, I'm currently the chair of the New Jersey Advisory Committee on Professional Ethics. And 22 years ago, we got an inquiry. I wasn't the chair back then. And I won't even say what side I voted on this, you might be able to guess. That asked quite simply, if a prosecutor is found to have exercised a peremptory challenge in violation of Batson, or in New Jersey, we call it Gilmore, does that violate what New Jersey had then adopted, RPC 8.4G, still does, which makes it misconduct for a lawyer in a professional capacity to engage in discrimination based on race, gender, and a number of other protected categories in New Jersey. And the committee, despite what some people argued was the plain meaning of RPC 8.4G, said no, it's not misconduct. That would have such a chilling effect on prosecutors. And the opinion even said, and you know what it might do? It might have the perverse effect of making judges less likely to make Batson challenges, to rule that there was a improper use of a peremptory challenge, knowing that it could trigger a disciplinary action for the prosecutor. So my own experience is that when there's been an attempt to actually use the RPCs in the context of the prosecutors, suddenly people back off. So I'm just wondering, and I think some of the questioners ask, how practical is it to use the ethical rules, given that for a lot of lawyers, using the RPCs is like using the major ammunition?
No, that's a great question. And that's one of the things that I have to really sort of interrogate with my work, right? The numbers out there, when you see the data available about how often prosecutors are found to have violated ethical rules, misconduct or any sort of bar forfeiture because of it, they're really small, even when you have situations where wrongful convictions occur because of egregious misconduct by the prosecutor. What I've sort of thought about is there are two problems with the rules as they're currently provided and how they're sort of managed or directed. The first is that although we now have a rule that's the special rule for the prosecutor, we don't have something that's so clearly in existence for the public defender, right? Public defenders are attorneys. They've got to, follow all the other rules that are prescribing to attorneys. But because the public defender isn't sort of isolated in that way, I think, there's not as much attention to the ways in which the prosecutor's behavior is making it hard for the public defender to provide the kind of assistance that these professional rules would require of them. So that's one. The second problem with the rules is that the policing, for lack of a better word, is just from attorney to attorney, right? And so that was going to be a question that I had for Mr. Oduye about sort of like the interaction between the line prosecutors and how often each of them are reporting another, right, for engaging in some sort of misconduct or doing something inappropriate with regards to a defendant or a defense attorney. One of the projects that I'm working on right now looks at how prosecutors and public defenders and judges learn from their mistakes, right? So if you have a case that goes through to conviction and then it's overturned or reversed on appeal because there's been some sort of violation, maybe official misconduct or something like that, how are these officers or the attorneys that were involved responding to that? Do they even learn about it? Or is this just something that exists elsewhere? One of the ways in which I think they need to respond is there needs to be some sort of mandatory or a sort of forced evaluation by the appropriate state bar entity, because obviously something has gone wrong, some sort of professionalism rule has been violated, and it's their duty to sort of manage the profession in that way.
It is 5:59. There is so much we could continue to discuss, but alas, our time has expired. I noticed one question which I will ask of Joe Nagel. It has for CLE purposes, has the post-program survey been linked, or is there anything that those getting CLE? All right, so there's something. All right, it has been, and it's in the chat box. Also, I ask all of you, all members, all attendees, who, and I hope that's all of you who continue to be interested in this area. A lot of what has transpired, our participants will be further publishing their work in an upcoming issue of the Rutgers Law Review. If I'm sure if you have any other further questions that you should maybe get in touch with me if there's something that you a piece of information you really want. We'll try your best to get that specific answer for you. CLE questions Joe has put in the chat box can be directed there. So with that, I again want to thank our fabulous panel. This has been a fascinating and a lively discussion. And I'll ask Professor Cohen whether she wants to make any parting ending remarks.
Well, first of all, I'd like to thank again all of our speakers. You came with your heart and your insight and your wisdom, and we so appreciate the thought and attention and passion that you brought to the conversation. So a million thanks to all of you. Just a couple of announcements. So the next program in this series is on Thursday, March 25th. And Adewale, I think that maybe you would want to tune in for this one, because we will be joined by 3 people who do head up prosecutor offices around the country, who have identified themselves as being progressive prosecutors and who will be exploring a lot of the questions that we were exploring together today. These include Chesa Boudin, who is the new not so new anymore, District Attorney of San Francisco, Diana Becton, who is the District Attorney of Contra Costa County in California, Parisa Degani Tafti, who is the Commonwealth's Attorney for Arlington County and the City of Falls Church, Virginia, and also Jamila Hodge, who is a former Assistant U.S. Attorney in DC, but has been for a number of years the Director of the Reshaping Prosecution Program at the Vera Institute of Justice. So just as today's conversation was engaging and thought-provoking, I'm sure that one will be as well. We invite all of you who are here to join us for that. and CLE credit will be available again. And I'd just like to give a shout out to all of the law students who helped put this together today. Gisele, Mary Claire, Jen Monhay, Madeline Gale, our inestimable editor-in-chief of the Rutgers Law Review, and all the other law review students who worked on it. And of course, always to Joe Nagel and Habiba Johnson, who make this all happen. So thank you, and much to talk about. I hope that the conversation will continue again in a couple of weeks. And I'll turn it over now to Gisele.
Well, I was going to say basically the same thing that Professor Cohen already said. Just thank you so much to everybody for joining us, and that the next segment will be on March 25th. We'll have several prosecutors, as you've already heard mentioned, and it's from 4 p.m. to 6 p.m. You should be receiving promotional materials soon in the next week. Some of you can already register through the Zoom link, but if you're looking for CLE registration, look out for our promotional materials next week. Thank you so much.
Thank you, everyone, and have a good night.
Thank you.